All right, I think we'll go ahead and get started if the panel is comfortable with that. Good afternoon, everybody. My name is Jeff Siebert. I'm the Director of Alumni Engagement at the Law School, and we're so happy you could join us today. We have a terrific program, and I want to thank our alumni, our amazing alumni panel, certainly including Steve Younger, who suggested this very relevant topic. So thank you, Steve. And certainly a special thank you to Danielle Quinn, who helped to organize it. Danielle's going to give the formal introductions of each of the panelists, but I wanted to be sure Danielle gets a proper introduction as well. So Danielle Quinn is an associate at Patterson Belknap Webb Tyler LLP's litigation department. From 2017 to 2018, she served as a law clerk for the Honorable Peter W. Hall of the United States Supreme Court for the Second Circuit. From 2015 to 17, she served as a law clerk to Honorable Richard K. Eaton of the United States Court of International Trade. She has been recognized in the area of commercial litigation, so that's a very relevant nod for you there. Danielle is a member of the Historical Society of New York Courts and co-chairs the Young Lawyers Committee of that group. So Danielle, take us away, and thank you all very much for putting this together and the work that went on behind the scenes for it.
Thanks, Jeff. So I'm here to introduce the rest of the panelists. We're honored to have Judge Christina Ryba here. She's a class of 2001 Albany Law School graduate. Justice Ryba is a justice for the 3rd Judicial District. And before joining the court in 2016, she held positions in the Office of Court Administration and at the New York Appellate Division 3rd Department. She's also a fearless advocate for Albany Law School. She served on the Albany Law's National Alumni Association and is a board member of the law school. We also have Professor Pat Connors here with us today. He's a distinguished New York practice professor and author of the New York Practice Treatise. He's also the author of McKinney's practice commentaries for various provisions of the CPLR and has numerous other publications in the field of New York practice and legal professional responsibility. We also have Steve Younger here, my former colleague at Patterson Belknap, who is now a partner at Foley Hoag. Steve is the former president of the New York State Bar Association and has been a commercial litigator in New York and federal courts for 35 years. And lastly, we have Brian Donovan. He's a partner at Harris, Conway, and Donovan, where his practice focuses on commercial disputes and personal injury litigation. He is also the past president of the Albany Law School National Alumni Association, is currently on the board of directors. So with that, I just wanted to sort of frame our discussion for today. Today we're going to be talking about the new changes to the uniform rules, with a particular focus on rule changes that are bolded in your agenda. As we go through this discussion, and I'm sure Steve will talk about this in a minute, the New York State Bar Association has opened the doors for comments on these new rules. At the bottom of page 3 of your agenda, there's an email address should you want to add additional comments and send those to the Bar Association. Also, with respect to questions during the programming, Jeff has kindly offered to field any questions. You can go ahead and submit them as we're talking about various topics, and we'll try to do our best to answer them as we're discussing, and if not, we'll make sure to cover them at the end of the program. So with that, I will turn it over to Steve to give us a little background on these rule changes.
Thank you, Danielle, and thanks for all your help in organizing this. Thanks to the law school and everybody who could join us today. Albany Law School has been known for its expertise in New York practice, going back to many of our mentors, including David Siegel, and who's carried on in that tradition, followed by Professor Connors, who we're really fortunate to have you. But it was always the stock and trade of we Albany law grads that we know New York law. So I think some of you may have been surprised at how many changes there were to New York practice at the end of this year. So I'm going to give a little bit of context for it. As a commercial litigator, Danielle and I have been living with the commercial division rules for decades. Danielle, not for decades, but for a long time. And I could say they work well for commercial litigators. They're applied differently depending where you are. So if you have Judge Platkin in Albany County, he deals with the rules differently than you do for the judges in Manhattan, because they all have individual practices, they all have individual ways that they apply the rules. And I think that that regional approach has really worked in the commercial division. There's also an advisory council that puts out proposed new rules or changes to the rules. The bar tends to weigh in on those proposals, and that whole process has worked very well in the commercial division. But I think many people were surprised because they were not sitting looking at the OCA website on December 29th when the administration announced that a whole host of these rules would be applied in our regular trial courts effective February 1. And that's led to a lot of consternation in the bar over just, how that transition period went into effect. Did the bar get adequate notice or the ability to comment on this? Or do these rules actually make sense, all of them, for practices like personal injury practices or matrimonial practices? Others say that these rules are just meant to improve practice, and not meant to be gotchas or set up defaults. And some say that there hasn't actually been a huge amount of change. So this is what we're going to discuss today. We'll discuss it on a very practical level in terms of looking at particular rules. As Danielle mentioned, the New York State Bar called for a pause in the rules back in April, and they've been taking comments. They have a July 1 deadline for those comments. So you'll see the email address at the bottom of the agenda, and I really encourage you, if you do have comments, to weigh in. So let me start with Professor Connors. I know you're on the CPLR advisory committee. What has the advisory committee done in the past vis-a-vis the commercial division rules? Have you had any input on these, and maybe you could talk to the process to how these came into effect?
Good afternoon, everybody, and thanks for attending the program. We will get comments from groups, and I believe in the committee's role as counsel to OCA on procedure. We did review the proposed rule additions, and we issued a report. I believe that's in our annual report. If not, send an email to Jeff and I'll make sure that I distribute that. That's a public document. But we went through the proposals and made some comments. I think some were addressed, many weren't. I would just state from my own position, I think this is an unfortunate development, but it is what it is. Steve, I would just confirm what you said. The State Bar has asked for a stay of the rules, but there has not been a stay issued yet, correct?
Yes, there's been some back and forth between the bar, as I understand it, and OCA, and to date, there has been no stay of the rules. They're still in effect.
Okay, and we've got a case we'll talk about later from May 6th where a court applied the rules. But just what we're dealing with now in New York civil procedure, we've got the CPLR, which is, let's see, it'll be 58 years old on September 1st, which, by the way, I think the Civil Practice Act was preceded, it only went for 43 years. Then we've got these uniform rules, and we've got now these 29 additions to the uniform rules. Then we've got rules for a judicial district. Ryan and Judge Ryba, you're familiar with the third judicial district's rule regarding disclosure of experts. Then you've got county rules. I see a lot down in Kings County that they have their own timing for summary judgment. Then you've got individual part rules, and then you've got an individual judge's rules. So I just think it's very complicated for the practitioner. And then to add these additions, some of which I think conflict with the CPLR, I just think it makes it very difficult for the general practitioner in New York State.
All right, so let's get into the heart of the issue. And what I want to start with is how the pandemic changed practice. And I know that the rules to some extent were meant to take advantage of a crisis with, with improved practice. So let me start with you, Judge Ryba. In terms of, I think one of the major changes is that we're now doing so many more things by vehicles like this, Microsoft Teams, Zoom. How do you see that working in your courtroom? How well has it worked? When we get out of the pandemic into more live court appearances, are there things that you're going to want to do live as opposed to doing over a virtual conference? How do you see this?
Thank you, and that's a very good question. I think the pandemic enabled us to look at ways to be more efficient, and I do think one of those ways to be more efficient is having conferences via virtual teams. That's the platform we currently use in the court system. And I think it helps not only the judges, but also the litigants who can be in Saratoga County Supreme Court, and they can then be in Manhattan, and then they can be in Albany. I find that it's very efficient. I can go through the scheduling order just as easily as if they were in my chambers. I would say I've also resolved cases and helped settle them during these virtual conferences. I do think that sometimes in person can be helpful when you're close to trial and there's that activity in the hallway. In Albany, we have what's called a part one, and any case that's scheduled for trial is heard by the part one judge on a very tight schedule. So there will be an opportunity for me to conference a case, and then the parties go in the hall with their attorneys, and then when they come back in, there's been some movement. With virtual, there isn't that much opportunity for those types of conversations in the hall to help resolve things. But I think on the other side, we've been very efficient with still having those settlement conferences. And I think because we were in a pandemic and people were so afraid of going into the courthouse, there were a lot more settlement discussions because there was such a delay and there was all this unknown. Yes, we are open now. I did preside over a jury trial 2 weeks ago, but it was quite different than we're all comfortable with. Everybody had masks on. They were 6 feet apart. The witness had a shield on their face. And so I think, yes, we will be more efficient with regard to conferences, but there are hearings that probably will be better suited to remain in person when it's safe. So I would say it's been a growing experience. We've gotten a lot better at virtual conferences and virtual proceedings, but there are some things that probably will be better off in person once we can get back there comfortably and safely.
Sorry about that. I think we all owe a debt of gratitude to the judiciary because you went through a lot over the last year and a half. And I saw a lot of patience from judges when many of us were having difficulty with things like not pushing the unmute button. And so we've all been through this together. Let me turn it to you, Ryan. One benefit of video conferencing is you can be up in Saratoga at 9 o'clock. You can be out in Amsterdam at 10 o'clock and then down in Kingston at noon. How has it benefited your practice? And are there things that you're really going to want to do in person as we go forward?
Sure, and thanks, Steve, for having me today. I'm honored to be on this panel. I obviously it's a double-edged sword, right? There's positives and negatives to this. As far as standard preliminary conference getting discovery dates, it's a wonderful tool. It's saving clients a lot of money, right? And when your clients are paying you to travel to Westchester and back for a 15-minute conference to get discovery dates, it's really not a good use of their money or your time. So from that point of view, I think it's wonderful. There are obviously things where virtual appearances make more sense. When the pandemic started, we had some depositions that had to get done in some more rural counties, and there was a lot of pushback on doing virtual depositions. And honestly, when it first started, I wasn't comfortable with virtual depositions. I didn't know how the exhibits were going to work. The stenographers have really taken on and evolved and have really been very helpful in getting the exhibits up on the screens. And for certain witnesses, it can still work. So we had to do some motions to compel depositions with some more rural counties. And so it was interesting to navigate that back last April and May. But as far as the negatives, I completely echo what Judge Ryba said. The personal contact you have with other lawyers, the relationships and the trust we've built over years and years of practice, that can't be recreated via keyboard or online. I think it's really necessary to have those relationships. Steve, I know in your practice, you can call on people you know, and you have trust that you built up and credibility you built up over years. In my experience, people are really tough when they write emails, but when you actually get on the phone with them or talk to them face to face, you have a better opportunity to work out disputes. So any significant conference on a complex case, I think really should be in person. I had a great opportunity on a very complex commercial case last month. Judge Walsh, Saratoga County called us in and we hammered it out for 4 or 5 hours and we got a resolution that was a bit unexpected. So I don't think we're ever going to be able to replace that in-person feel.
Yeah, and I serve a lot as a mediator, and I've done a number of mediations during the pandemic, and it surprised me how well you could, get to a settlement. Although I still personally would like to be in person and be able to say to the person, you really should settle for this reason. One judge told me recently that the Microsoft Teams platform doesn't have the subgroup function that we use to caucus. And so I'm sure that the court administration is trying to improve on that because it will allow you to break people up. Let me turn to the first of our rules, which is Rule 1. And it gave me a little surprise that people actually found this rule disturbing, because it basically says whoever shows up needs to be knowledgeable. Well, I always was taught in law school, we have to be prepared when we go to court. I think part of the pushback has been in, for lawyers who have a lot of volume cases, lawyers who hire per diem lawyers. But let me start with you, Danielle. And for the young lawyers in the audience, so someone calls you, that morning and says, "Oh, we got an appearance down in court. Go cover it." What do?
Well, you go. But no, I think one of the things, I understand that there's some concern about maybe younger attorneys showing up, but I don't read the rule to say you have to have settlement authority when you show up at a preliminary conference, right? If a young lawyer goes, he should have the authority to be able to enter into a discovery schedule, agree to dates and move the proceeding along. And those are things that are, I'm a 6-year associate, that should be within our wheelhouses depending on the case and the client. And so I don't think this rule actually discourages younger attorneys. I think it's more probably focused on a per diem lawyer who will show up and not have information about the case, or be able to say that we'll, produce certain documents by X date or disclose experts by X date. But I, subject to others' thoughts on that. Probably Justice Ryba's thoughts, actually. But that's just my general take on that rule, that it's not going to affect me per se. And often Steve or someone would go with me, at my first preliminary conference. I would be there with someone who's watching me and observing me, to help me and teach me. So.
Yeah, and it's important to note that rule talks about having authority for the issues at that conference, not like everything in the case. But Judge, how do you feel? I know a lot of judges want to promote the ability of young lawyers to handle matters. I personally think when we're talking about discovery, the associates know more about discovery than I do. So how do you see this rule causing any problems, and how do you encourage people to allow more junior lawyers to appear?
I really like seeing junior lawyers appear at conferences. We've all been there. That's how we start, and that's how we learn. I think this rule is just what Ms. Quinn indicated, that it's to preclude or to dissuade the per diem showing up and not knowing anything about the file. And that's unfair to the other side, because people are paying for their attorney to go there and move the case forward. And if one side doesn't know anything about the case, they don't even know if they can enter into a scheduling order because they don't have the calendar of the firm that needs to be at the next conference. It's really not fair. So I don't think it's going to discourage younger attorneys from coming. It's going to discourage people who have no idea what they're doing from showing up at the conference and wasting everybody's time. So I think it's a win-win for everyone. And I definitely don't think it's going to impact younger associates coming into court.
And what I often advise younger associates is that, and I'll always be the younger lawyer, but anyway, is you should have been preparing me to go to the conference anyway. You should have given me an outline. You should have, laid everything out so that you should understand what's going to come up is probably better than I would. So that if somehow you get sent down there on a moment's notice, you should be prepared for that file. All right, let's talk about Rule 8. And let me turn to you, Professor. Basically, what Rule 8 does is to try to front end load the case. So you're supposed to consult before the first conference about things like resolving a case, discovery, ADR, voluntary exchange of information. How does this change practice? Was there anything in the CPLR that required us to do this, or anything in the uniform rules that required us to do these things before we first showed up to see a judge?
Yeah, there was. By the way, this is on page 23 of the materials. And as Steve mentions, this is new Rule 202.11, consultation prior to preliminary and compliance conference. It used to be, and it still is in the rules, but 202.12b says that where the case is reasonably likely to include e-discovery, Steve, we're involved in a case, it's reasonably likely to include e-discovery, we have an obligation to consult. Well, now we've got an obligation to consult about all sorts of things in this 202.11 at page 23. And I just want to backtrack a little to this idea that a young associate can come to a conference and not have settlement authority. I'm thinking back to my day when I was a baby lawyer and I went over to Supreme Court Onondaga County to appear before Justice Pooler, who was a Supreme Court judge at the time before she went on the federal bench. And the plaintiff's lawyer was there, and the plaintiff's lawyer knew Judge Pooler, and I think they were at the Syracuse football game that Saturday. And I walked in representing the defendant insured, and she said, Mr. Connors, what kind of settlement authority do you have? And it was one of these, where I got the file about 45 minutes before I went over. And she wasn't too happy about that. I think she would have more grounds today. She adjourned the conference and said, I'm going to adjourn this for a week, and Mr. Connors, you better not, come back without authority because you're wasting everybody's time. But if you look now, I think that the preliminary conference itself under 202.12, one of the issues is settlement of the action. And then you have all sorts of other conferences now that are weaved into the rules. And I think you'd be hard pressed to go to any kind of conference today without some kind of a authority to settle and being fairly knowledgeable about the case. But yes, Steve, this was in the CPLR or in the uniform rules in a limited area. But now this is expanded to all sorts of things where we have to, confer in advance of a conference.
So Ryan, let me turn to you about settlement and mediation in particular. And by the way, the commercial rules have requirements that weren't brought over. Like virtually every time we make an appearance, we're supposed to have talked to our client about ADR. Do you feel any pushback in the court system telling you should try to settle a case before you even show up in court? Do you have any concern about ADR, or does it actually give you an out to be able to say to the other side, hey, we really should talk settlement because the rule says we have to talk settlement?
Well, I always enjoy the court pushing settlement on parties or bringing up the discussion because there's always the back and forth of you don't want to show weakness in your case. How do you bring up that issue of settlement? And having the third party, the court bring it up allows you to save face in your negotiation. That might be more of a practical approach, but if I show weakness that I'm willing to settle, that might decrease the number depending on the facts and circumstances. So I'm all for the courts getting involved at an early part, but I do a lot of federal practice. I have a lot of cases in federal court, and a lot of these rules are really bringing a lot of the federal practices and rules over and codifying some common sense, I think, as well. But sometimes it doesn't fit and we get forced into mandatory mediation in federal court and it can be a waste of time. So I think that you have to make a good faith effort and discuss that with your clients. But in commercial cases, people are emotional in the beginning or they're upset. Obviously, they brought a lawsuit. They may have to see a couple months of legal bills before they really realize what they're in for, before they think, oh, maybe we should resolve this. And in personal injury cases, sometimes the injuries haven't developed fully, or in most cases, the insurance companies really want a deposition of the injured, of the plaintiff, before they can make that call. So I'm fully behind ADR becoming mandatory on the front end, but I think the court should allow, and we've done this, we've written letters in federal court to say, this really doesn't apply to this case, and here are the reasons. So it obviously is very beneficial.
And people should be aware that before the pandemic, the chief judge had what she called the presumptive ADR program. It was just starting to take off and had not been fully implemented. But I think there has been a push for, more early mediation. Judge, I think, given the backlogs that we're seeing because of the pandemic, do you see more use of mediation in the court system going forward?
I think it depends on the type of case. Now, Albany County, you have to understand, doesn't have the same backlog that perhaps New York County has. So I don't have a backlog in my chamber whatsoever. But I do think ADR has become just part of our culture now. I ask about ADR at every conference. We do have court referees that I can send cases over to have the court legal attorneys mediate. And then there's also now a roster of mediators, but Albany's already had robust mediation practices that are known to the community of attorneys and to the community at large. So have I seen more? I think there's always been a certain number and it's still there. I mediate cases, the referees do it, but I think every case is different, obviously. And some cases just aren't ready until you get closer to trial. So I think it's not one size fits all. And sometimes if somebody thinks they have to do something, they're not going to put their energy into it because they're not ready for it. So I think I look at each case individually and have a real conversation when it's time. Sometimes that preliminary conference, it's obviously too soon. Depositions haven't taken place. The parties need to get more information. So I think if you send everything to ADR before you do any discovery, I think that's probably going to be a waste of time. So I think, have I seen more? I guess I'm not really keeping track, but I do know that the culture has shifted and we do talk about it a lot more now as judges. So that's a movement in the right direction, I think.
Yeah, just one practice tip for the audience. When I try to get an early mediation, I also talk about exchanging information because you just can't sell a case without, and it's focused. It's not like don't give me every document. What I want are the following 1, 2, 3, 4, and I'll agree to just exchange it for settlement purposes because it allows us to have a meaningful discussion. Let me stay with you, Judge, on Rule 34, which is staggered court appearances. My sense is in many courts, you weren't having, what we call the cattle call, where you'd be in court and you'd hear, I don't know how many cases, and you sat around and waited. Have you had that any time in the recent past?
I've not done that since I've been on the bench over 5 years. I have not. I've heard about it. That's something of the past, but we don't have a calendar call where people are just waiting to be called and have their case heard. So specifically, let me pull up. So it's Rule 34, Steve, that you're referencing?
So now all judges are encouraged to have staggered court appearances. And I get the sense in Albany County, you've been doing that for a long time. I think that may be a New York City thing where you would go to court at, called for 9:30, nobody ever showed up before 10. I can tell you, a particular county where the Yankees play, a lawyer would check in, then they go to another courtroom, and then by 11 o'clock, you'd actually be called, which, was just, I think it has to do with the volume of those courthouses.
That's not, County doesn't have every
I'm sure it doesn't happen in Albany.
I think, obviously Albany's not New York. And so we don't have the same volume. We don't have the same issues that those courts have.
Right. So let me turn back to Danielle and let's talk about discovery. So one of the big things that is in the commercial division rules is this concept of meet and confer. And I know that you probably spend a lot of your time in discovery, meeting and conferring with the other side. It's a term that didn't exist when I started practicing, but that was when the dinosaurs were still roaming. Should I just assume that the other side's going to tell me to pound salt, or when you meet and confer, are there things that you can actually accomplish?
Right. So there definitely are things you can actually accomplish. A few things. Typically what happens is you will serve your various discovery requests, and a lot of the meet and confer stuff will happen early on when you're negotiating things like search terms, custodians, certain non-custodial files. So you read the discovery requests, you go to your client, and you do an investigation to see what you think is responsive, and you get a sense of the estimate of what you're looking at. It could be 3 different databases to 40 different individuals that you'll need to talk to. And from there, you try to figure out, okay, what do they actually need that's responsive to their requests? And once you're armed with sort of the size and nature of your discovery response, you then try to set up a call with the other side to just discuss ways that you can limit or narrow and give them a full responsive request without placing like an unreasonable burden on yourself or your client to gather all the information. A lot of the meet and confers happen so often, it's not like it happens once. So once you go through that steps, you may have that step that I just described, which is sort of this investigation period and initial response. You also then will continue to have issues as you go through and find out more information about how to narrow or respond to requests. Sometimes, and coming at it with this understanding, I think is helpful. The other side doesn't know what you have. And so the requests are always going to be broader than, and in enlightening them on, what they actually need or what is responsive is sometimes helpful to get you to sort of a more narrow discovery production that's better for everyone. So whether it's negotiating search terms or the number of individuals who have these documents, those types of things are typically what's resolved pretty easily.
Yeah, and this is under Commercial Division Rule 11, which includes section 202.20A, which is about privilege, 202.11, which is consulting before conferences, and 202.20F. And Professor Connors, and we already had this good faith, certification we had to submit on a discovery motion. How has this really changed practice to have these meet and confer obligations?
Yeah, we have it in 202.7, Uniform Rule 202.7A and Uniform Rule 202.7C. I addressed that in the book. It's section 353. I've got a section for the requirement that on any motion.
The book is New York practice.
Yeah.
The book.
Yeah. In section 353, it is a subsection there. And basically it discusses the uniform rule. It's been around for a long time. 202.7A and C that say, when I'm making a motion against Danielle in a case and it pertains to either disclosure or a bill of particulars, I've got to have an affidavit of good faith that I tried to work it out. John Higgett from the class of 2001, Judge John Higgett, who was recently appointed to the appellate division, he has a case that I included in the supplement where he said, there is that requirement and there is not a good faith affidavit with this motion that pertains to disclosure, but I don't think it's something that the parties could have resolved anyway. So I'm going to basically ignore the fact that they didn't try to work this out. Steve, the difference here, though, is the consultation, the meet and confer has to happen before you even have a dispute. The current or the uniform rule that I mentioned, 202.7, contemplates an actual dispute requiring an motion. But these rules now require a meet and confer in advance of any known dispute.
So,
right, that meet and confer could cover sort of like discovery scheduling. I mean, if there is no dispute, right, then you would probably have a call to figure out exactly how you want to go about discovery. We typically enter into these things called protective orders, where parties will agree on, really before you even produce a document in the case, you enter in a protective order. And in that protective order, you define what is confidential, what is highly sensitive confidential information, what you're going to do with privileged information, and all of that stuff can happen before that can cause some fighting too, but sort of sets the groundwork to streamline the discovery process a bit.
Right, let me turn to you. How do you see this meet and confer obligation playing out in your practice?
Well, as I said, in federal practice, I've seen it quite a bit. I had a case in Oregon and we had disputes going, many motions in this case. And counsel would chuckle and call, okay, here's our meet and confer. We've just had it. Now we can put it in the motion and go ahead. Because if you're at the point of making
it's pro
motions,
forma.
Yeah, exactly. And if you're at the point of making motions, a chance of you hashing it out on the phone, they're not very significant. You look at 202 20F, you can't do this via email. It's got to be either in person or telephonically. Interesting, now in your certification, you had this conference, this meet and confer. You have to tell the time it happened, how long, who is involved. So it's put more, this rule is put more on drafting the motion, more that you have to remember. I think that's really the significant part, because if you're making a motion, I assume this dispute's been discussed either through letter or some fashion before you got to this point. If it's a summary judgment motion, I doubt you're going to get a meet and confer to resolve that. So I've seen this, but I don't see this being effective in resolving issues. This really just seems like another hurdle or another requirement to be included in your motion.
Okay, let me turn back to you, Judge. What I think a lot of lawyers are saying, I'm really concerned that if I don't dot all my I's and cross all my T's, I'm going to walk into court on a discovery motion. They're just going to, throw the book at me, sanction me, default me. Suppose someone didn't follow this rule, they didn't confer. What would you do?
In the 3rd Judicial District, you have to file a letter seeking a conference before you file a discovery motion. So we already have something. So you can't just file a motion to compel without having a conference first. But if it's outside of the scope of that rule and they didn't follow it, I think I would see if the other side is bringing it up as an issue, and then I would give them an opportunity to cure it. I wouldn't dismiss it or say you have to refile it, because that's just a waste of everyone's time. And I think in preparation for this conference or this program, I spoke to Judge Placken a little bit about the commercial rules and the purpose. And it's not a one-size-fits-all approach, and it's really to try to make things move efficiently. And so I don't really think there's supposed to be, I'm not going to say broadly that each rule is just a suggestion, but I think that there is some flexibility there. And I think most judges are going to be reasonable, especially since these are new. They were rolled out in the middle of a pandemic, and people were nervous just to see, something changing so quickly while our lives were upside down. So I think we're all getting used to the rules. We're talking about it more. We're having conferences and we're having these types of programs. So I think, some attorneys might not be aware of each specific rule until somebody else says, hey, you violated it. I'm going to move to have your motion dismissed. And then I think the court will most likely allow the one side to cure it if it's not prejudicial, and then go from there. I think that makes the most sense.
And Danielle?
I was going to say, yeah, I think that's probably the case, except for Professor Connors might want to talk about it, but one of the rules, Rule 19A, was what I was going to transition.
Well, let's get to Rule 19A later, because that's really more in emotions. So I think, from my perspective, any court rule is meant to improve practice. It's not meant to be a gotcha, and I think we have to rely on the discretion of our judges to implement these rules. And that's what we see in the commercial division. I rarely see a judge say, oh, you didn't file this, I'm throwing your papers out. That just doesn't happen very often. So let me just say, okay, go ahead.
Steve, can I just speak to that? I think that's what you see most times, and maybe in your experience, what you've seen. But when I'm reviewing cases, reporting cases, I often see that a court will, and an appellate division will affirm. A court will just really not deny the motion, but dismiss it and say, It's not procedurally appropriate. You don't have a good faith affidavit. And this is supposed to improve practice, but let's look at this for a second. What's going on here? Danielle, I want a document from you. So I serve a 3120 demand on you. You got 20 days to respond. You don't respond. All right. Well, now I guess I got to give you two or three extensions so I can show that I tried to work it out. Still nothing. Now I've got to meet and confer with you. I've got to show that we try to work it out. That doesn't work. Now I've got a motion under 3124 to compel you to produce the document. The Judge Ryba grants that motion and issues an order requiring you to produce the document. You don't produce the document. Now be careful here because I've seen this too. So now, Danielle, you've disobeyed a court order. Now I can get sanctions under 3126, which might mean, if you're the defendant, that you're going to be found in default. But I've got to do another attempt, make another attempt to try to work this out because my 3126 motion is a motion for disclosure. All right. You don't give me the document. Judge Ryba, I'm back with you now, making a motion under 3126. I've tried to work this out twice. Judge Ryba issues a conditional order saying that now, Danielle, you have 20 days to produce that document. This is crazy. Ryan, you mentioned the cost of the client. This is insane how much time and effort we've had to spend to get one or two documents. And now the judge issues a conditional order. And Danielle, you don't comply with that. There's a dispute in New York practice about whether the conditional order is self-executing or whether I have to go back to the judge again. So Steve, I think there could have been more attempts to resolve that problem on the back end than adding in these additional requirements about, meeting and conferring, et cetera, that you referenced there on page 40 of the materials. So I had an article I did a while ago called Conditional Orders Can't Get Any Respect. And the best part of it is the first two paragraphs because it has all these Rodney Dangerfield jokes. But it really is true that conditional orders in New York oftentimes don't get the respect that I think they need to get to make litigation more efficient. Thank you.
Yeah, and I think a lot of this really depends on who you're dealing with, because if you're dealing with an obstreperous adversary that doesn't do anything is one thing, whereas if you're dealing with two reasonable lawyers, it's a completely different experience. So let me just stay with 202.20a. There's a preference now for what are called categorical privilege logs. Danielle, can you just explain what those are and why that makes it less burdensome and less expensive?
Right, so maybe it's helpful to describe in a regular privilege log, what you will do consistent with the protective order is describe by identification number, either a Bates or document ID number, the actual document, give it like a subject matter tag, deal document, communication, or something that describes the nature of the document, the date, the custodian, who's the individual who has the document or email, and then other people maybe who are on the email exchanges. And in a case where you have millions of pages of documents, and there are, thousands of privileged documents, sometimes even more, to go through and identify that type of information for each document can be challenging. What a categorical log allows you to do is create different categories or groupings of documents that you're going to assert privilege over. So some examples of categories or ways you can group documents would say like documents and communications relating to XYZ deal. And then, or it could be like marketing, legal advice relating to X product. And then you list the number of documents that would fit within that broader description, the date ranges. You'll include some information about file extensions, if it's a PDF, if it's a Excel spreadsheet, what types of documents they are. And then you list all of the different individuals that are either their custodians or who those documents are to or from. So what it does is, like, for example, that group that I described, that could be 250 communications, and you would have asserted privilege and described the basis for asserting privilege in one group, as opposed to doing it document by document. So that is why it's helpful. And often when you're in these larger scale document discovery situations, you're able to use metadata and various tools to sort of group the documents in this way. Now, if you were going to do something more like an individual log, your subject matters would be like analysis of deal, and you would have that for every single document. So this just prevents or sort of tries to streamline the way you're producing documents. You know, there's some pushback to this, obviously, because you're not going to have as much individual information. But the way that you would challenge a document in a privilege log, in theory, you should be able, if the person is doing the categorical log the right way, you should be able to have the information that you need to make that challenge.
So there's an area where these rules are meant to make things easier, simpler. Let me turn to you, Ryan. There are other limits on discovery that are more controversial. In 202.20, there's a limit to 25 interrogatories. I don't know how controversial that is. But the big one is 202.20-B, which limits depositions in number to 10, but more importantly to 7 hours. So you're in a multi-party case. There's a crane operator, there's a construction supervisor, there is an architect. How do you deal with the fact that you're limited to 7 hours?
Well, that's always a challenge. It's been a challenge in federal court. I don't mean to keep echoing this federal practice, but this has really already been happening for years in federal practice. And I've had to go to magistrates and say, listen, we've got 5 defendants with different thoughts on how this deposition should go. And a lot of the time we get told, well, work it out. You're getting 7 hours. So you really have to make a well-explained reason why you should get more than 7 hours. And honestly, 7 hours is a long time. The stenographers are usually tracking the time. If it gets contentious, we've gone right up to the 7 hour mark. But, when I was reading some articles on this week, you bring up the crane operators, Steve, but really it's going to be an issue in medical malpractice cases. When you have, and that's, we see a lot of that, obviously everyone sees, but in the personal injury practice, med mal, you're going to see several doctors have different attorneys who have different ideas of how to depose the plaintiff. And I think, and actually was speaking with Judge Ryba, so not to pass off my responsibility right now, but I was speaking with Judge Ryba about this yesterday, because I think she's going to start to see a lot of applications for extensions of time. And as far as the 10 deposition goes, if the facts of a case took a long period of time to occur, if it was treatment over years, it was a misdiagnosis case, these limits on the amount of depositions could be restrictive. I would imagine that the upstate judges, I could speak, are pretty reasonable. Obviously, I doubt counsel will get to too many stipulations to extend past 10, which is you're allowed to stipulate past 10 parties or 10 witnesses. But I think you're going to have to really show that it'd be prejudicial not to. So I'm going to bring Judge Ryba on this, if that's okay, because we did speak about this yesterday.
Sure. Yeah, let's start to you, Judge, and just as background, 1, you can stipulate out of this. 2, there are some factors in the federal rules, like, which is where this rule comes from, which are like, are there multiple parties? Is the witness with a translator? Are the lawyers adversarial? We don't have many of those, I'm kidding you. And the other thing to remember, it's 7 hours of running time. So the court reporters keep the time typically, and that tends to go more like 6, 7 o'clock at night if you do the actual time. Now, we used to take more time for lunch before the pandemic than we do now. But Judge, imagine you have a dispute over this. The lawyers come in, and I think one of the things that I've heard from defense lawyers is there's no incentive for the plaintiff. They only have one party to stipulate to give any more time. What are the kinds of things you're going to look for?
Right. So the rule says for good cause shown, the court may alter the limits on the number of depositions. So what is good cause? I would have to make that decision on a case-by-case basis, but I was thinking, no, I haven't had that request yet, but I do think perhaps if there was a legal malpractice action and the attorney represented somebody for multiple years and there's multiple transactions, then an extension of time would make sense. Perhaps that would need to be a 2-day deposition versus a 7-hour deposition. So I think the reason why the rule has that good clause shown is to allow the judges to listen to why the extension is being requested. And like Ryan said, 7 hours is a lot of time, but it has to be put into perspective. And so it's not a lot of time if somebody's represented a client for 30 years, and now there's an action, a legal malpractice claim that is linked to many different transactions. So again, I would listen to both sides and make a decision based on whether or not the good clause was shown.
And also, Steve, on the limit to 10 depositions, I do think it's a good thing as far as limiting the expense. We have some smaller commercial cases up in upstate New York as compared to what Danielle's referring to, and all these different types of privilege logs. Obviously, our clients might be disputing things of a lower monetary value. And oftentimes, the party with the most money can outspend the non-moneyed party, and it can really become unfair. So in a way, that does create some fairness in litigation where we can actually get to the merits, not just who can afford more attorneys or more depositions.
You don't need to end this conversation, but I need to give the first code, which is court, and then we'll give the second code at the end of the program. All right, everyone continue.
Very creative.
I think it's actually courts plural, C-O-U-R-T-S. Yes, C-O-U-R-T-S. There it is. Great, with a beautiful picture of our alma mater in front of it. Okay, let me swing back to you, Professor. There's one particular rule which I think comes out of meet and confer, which is 202.20C, which now says that you need a specific response. So you can't just say burdensome, irrelevant, privileged, whatever. You have to say if you have a document, which I think is a good development, because I might be fighting with Ryan over a particular document demand, and we have nothing to fight about because there aren't any documents. How do you see this changing practice in real life? Are lawyers going to have to update their forms? Are they going to have to do different things to respond to rules like this?
I don't think so. Maybe you have seen this in the commercial division, but I think this is right out of CPLR 3122A and the surrounding sections. That, remember, it was years ago, Steve, if I asked you for 50 documents, you might just respond up, they're all irrelevant. And we amended the CPLR back in the 1990s to require that you particularize each objection and provide all the documents that are unobjectionable and relevant. It seems like that's what this is requiring. And then you've got the supplementation requirement here. This is on your page 33 in the materials, this rule 202.20-C. And this one was interesting. Item C of 202.20-C. By the way, the numbering system here is deadly. I wish somebody would attend to that. But it's subparagraph C. In each response, the responding party shall verify for each individual requests whether the production of documents in its possession, custody, or control, and that are responsive to the individual request as propounded or modified, is complete. Well, you always had to do that. And then you've got the supplementation requirement, which is noted in subsection D, 3101H. So I don't know, maybe there's something I'm missing here, but I was wondering what in fact this added.
So I think in practice it does make a change, because rarely does a lawyer actually say no documents in response to a demand. I rarely see that. So it actually makes us do that. And actually there's a rule that didn't come over from the commercial division where we actually have to update our responses near the end of the case, to say, what we've actually found and what we haven't. But, personally, this may have been there already, but I don't think lawyers followed it. And we'll see if they start following it now. But the idea that you will actually say, in response to request 22, we have no documents, that actually, then I don't have to worry about that. It just takes that one off the table. Yep.
What you say is after a reasonable investigation,
Yes.
You do your best and then try to confirm whether there's something there or not.
Right. All right. So let me stay with you, Professor, because I know you also dabble in the federal rules. Before this change, we did not have the equivalent of what's known as a 30B6 deposition in federal court. So, what I heard from trial lawyers was, they're trying a medical malpractice case. They take a deposition of, the hospital, and nobody recalls like how much Pitocin Mrs. Smith actually got when she went into labor. The record says it's X. Well, we gave her Pitocin. Now you can require the hospital to produce someone who actually knows, what Pitocin levels the plaintiff got administered. How would that actually change practice in New York?
Here's another one, Steve. I'm looking, I think you're referring to Rule 11F, which is on page 35 in the materials.
Yeah.
This was your commercial
202.20-D, deposition of entities. Yeah.
Yeah, right. It's commercial division rule 11F, and now it's 202.20D. This is another one. It's in the CPLR, and 3106D of the CPLR basically says, Steve, you're representing the corporation. I've got the plaintiff. I can notice Mr. Smithers in the corporation for a deposition. And then you have the right, really for the last word, as long as 10 days before the deposition is scheduled, you say, we're not producing Smithers, we're producing Homer Simpson. And then I'm stuck with Homer Simpson. And I guess I have to then take the deposition and try to show that Homer Simpson doesn't really have the knowledge that I need. Correct me if I'm wrong, but I think that's the way I see 202.20D playing out, and recognizing that if Homer Simpson doesn't have the relevant information, I can go back to the court and ask Judge Ryba to order you to produce Waylon Smithers. I don't know. Is this a change?
From what I hear from trial lawyers, it is. But in my practice, we've been doing this for a long time, it does. And maybe Ryan, you could weigh in on this. It does make a defendant, actually think about who they put up for deposition. I tend to, in a deposition for an entity, put up the person who's been responsible for the case. There's typically a business person who is your, person, because you can't educate someone on everything that goes on in these complicated cases. Sometimes you might put up multiple people in response to a 30B6 deposition. But Ryan, how does this play out in federal?
Well, in 30B6, for a federal case, it's fairly simple. We've been doing it in state practice, at least in upstate New York, but it's usually based on the reasonableness of the attorneys involved. Hey, I need someone that's going to be able to speak to the HR of this hospital, or how accounts are managed, or whatever the topic may be. And usually lawyers, in my experience, have been cooperative in trying to provide that. Every now and again, you get someone that may want to play games or really didn't do the investigation and called their client and put whoever they wanted up. In that case, you're just pursuing more depositions, and it creates more animosity where it's not necessary. When you can cooperate, you should. But so as far as it's playing out, I don't think it really changes much. Honestly, I think we've been doing it as a part of practice. It just wasn't codified.
So let's talk about discovery schedules. Now the rule says discovery schedules have to be strictly adhered to. So, Judge, I come in and I say, well, we didn't really get to all the discovery. we're supposed to be done by Memorial Day. I got a vacation planned. Can we have to July 4th? What's your usual reaction to requests like that?
I mean, it depends on how old the case is. So we have standards and goals, and we want to complete a case in a certain period of time, depending on what type it is. Now, the pandemic threw a wrench in almost every case that's pending. But if it's a reasonable request and the parties tell me why they couldn't depose certain individuals, and if it's not asking for 6 months versus a month or 30 or 45 days, then I'm likely to grant it to help the case move along and get to the end. But some attorneys do take advantage of that flexibility, and that could be frustrating because the case needs to move along. The parties need a resolution, and it's frustrating at times when there are attorneys that show up and no discovery has taken place. It's very rare, though. Most of the attorneys are trying to get their case moving along. So it does say in the rule that non-compliance with such an order may result in the imposition of an appropriate sanction against that party or other relief pursuant to CPLR 3126. So I've never sanctioned anybody to date for a discovery issue, but you never know. I'm not going to make any promises, but that's not the way I like to operate. So I'd say if it's a reasonable request, I'm going to grant it. It's great that the rule says that discovery must be complied with, but is that reasonable when, if you can't get the doctor to come to his deposition because he's traveling and then he gets back and then he gets in a car accident? I mean, what are you going to do? Go depose him at the hospital? No. So if it's reasonable, I think every judge would grant it. Most judges, if it's unreasonable, it depends on who you're getting. If you get a judge who is very strict with those deadlines, then you might not be in a good position. So I really think it depends on the judge, but most judges are reasonable, especially when it's something outside the control of the attorneys.
So let me turn to you, Danielle. You've probably been in the middle of quite a number of extensions of discovery schedules. What do you try to show the judge to show that, an extension of a discovery schedule is reasonable? I think we just lost you. There you go. You're back.
Back. We typically don't wait to the last minute. So we've already undergone substantial discovery. We described the limited nature and basis for the extension. It could be the case that, it depends on if it's for depositions or for document productions. We also often produce documents on rolling bases for these reasons. So describing sort of what you've done to do your homework to meet the deadline is typically what you do.
All right, let's turn to motions.
Steve, can I mention one other point on that? And maybe you've seen this in the commercial division, but it's on page 44 of the materials. This is helpful. It's the new 202.10. And if Danielle, if we're before Judge Ryba and you're having trouble meeting the deadlines, it makes the point that an adjournment of a conference, like a compliance conference, is not going to change the deadlines in the preliminary conference order unless it specifically says so. So that's something lawyers need to think of, to not just move the conference, maybe a compliance conference, but ask the court to adjourn the dates in the preliminary conference order for disclosure.
Right, and you should probably file a proposed amended order that with the new dates. So, and you should look at the judge's local rules. Sometimes the judges will have like actual forms that you should fill out and follow, but you want to look there and then give them something that they can just sign off with the new dates after you've gotten an extension. Or when you're requesting one, you can submit a proposed order too. Often what happens is you don't just go to the judge and ask for an extension. You talk with the other side and the both sides agree jointly that we're going to need some more time here. And then I think, Judge Ryba, correct me if I'm wrong, that those are more likely to get signed if everybody's figured that this is necessary to move the case along.
Absolutely, yeah. If it's on consent, it's much easier to deal with.
Yeah.
Steve, one practice point that's pretty obvious, but I think it's really important to ask for permission, not forgiveness. So making sure you're way ahead of that deadline lets the court know you're actually calendaring this and thinking about these cases and, not in hindsight. So I know it's written in 202 20E, but I think that's just a good practice for anybody, because otherwise it's, oh, this case isn't that important. Oh, I missed a date. I'll just write the judge. And that sends the wrong message.
Yeah, and I must say that the theme of the commercial division is case management. The commercial division judges are known for, being very interactive in terms of managing a case. And I know that that's how things are done in the Albany Supreme Court, not so much in some other courts, but I think that's kind of the theme of the rules. So let's
And
turn to
Ryan,
motion.
that's also just if you're keeping score out there, that's also in that document that we used to use, the CPLR. It's right in CPLR 2004, that factor, whether the deadline is passed yet. And that is a good point.
Okay, so when we get to motions, there's one that, kind of threw me, Judge, which is there's a maximum of 3 adjournments of a motion or 60 days. Does that change anything in your court?
Which
Could I
what
adjourn?
are you on?
Yeah, this is Rule 16, 202.8A. I can only adjourn a motion for a maximum of 60 days now.
Okay, I think it's a case-by-case basis, and I'm not sure if there's flexibility there. I don't know, Connors, Patrick, is there flexibility if I want to grant them, if they ask for 90 days?
Yeah, I
We're
think
talking
there is
settlement.
there is flexibility, and this is, I think, one of these hidden provisions in the uniform rules. It's also in 202.8 E1, which has a very similar rule, but I think the judge has that discretion unless the court orders otherwise. And be careful with this. There's a case, I just wrote it up, and it'll be in the next supplement to the New York practice book, which is coming out in about a week or two. Migliosino is the name of the case, and it's in section 281. And there, what happened was the lawyer wanted to adjourn a return date of the motion, but down there, you have to do that 48 hours in advance. And that's also referenced in these rules. And the second department basically affirmed the trial judge who granted the motion and said, you were untimely in seeking an adjournment of the motion. You didn't have your papers in on time. The summary judgment had to be awarded against you. These things are, I think, becoming more and more recognized by the courts and will be enforced by the courts, even though they're, technically not in the CPLR.
That sounds punitive, but if that's the way it went, that's the way it went. So that's interesting. I guess it's very important for the practitioners watching to pay attention to those deadlines, because if the other side is going to make a motion to dismiss your case, the judge has to rely on case law. So if that's where was that case, Professor Connors?
It's a second department case.
Okay.
That came out of Westchester County, and it's called Migliosino, and I wrote down the site, and give me 1 second here. I'll find the site and get it to you guys later. Go ahead, Steve. I'm sorry.
If you find it, you can just put it in the chat too.
So so much flexibility we have as judges, and we have to apply the laws that are in place. So I would likely give an extension if there was no opposition to it. But if there's opposition and then they rely on case law, then I'll have to look at whether or not the case is similar enough to have to rely on that type of precedent.
Okay, it's 184 AD 3rd 818, 184 AD 3rd 818. And I thought that was relevant to, among other rules, this rule, the new rule 202.23, which is based on the Commercial Division Rule 34 on page 71 of the materials. So it's Miglionico, that's the Irish pronunciation, 184 AD 3rd 818.
All right, let's talk about the form of your papers. And this is a major change. First one is all papers have to be in 12-point font, 10-point for footnotes. So don't bury lots of stuff in footnotes. I don't encourage that anyway. But I think more importantly, there's now a limit, and it's not just briefs, it's also affidavits to 7,000 words, translates to a little over 20 pages, and you get, roughly, 4,000 for reply, and you have to have a certificate of compliance. Danielle, you're working on a brief. You turn it into the partner. It's 30 pages long. What do you do?
You start cutting. No,
Right.
short,
Or I start cutting.
short and concise is always important. And I think that 20 pages is actually a lot of pages. No, but these rules, like many of the rules, permit you, if you plan ahead, to ask for extra pages if you need time and you need more space. And it's the same thing that I said with the conferring with the other side. So if for whatever reason, and we've granted these opposing counsel, you think that you need 5 extra pages, you need 25 pages, you can shoot your opposing counsel an email, explain that you would like to make a request for extra pages. Would they sign off and agree? If they say yes, then you can submit a request to the judge. But 20 pages is a lot of pages. So I think it really depends on the nature of your case and what you're briefing. I defer to Judge Ryba. She probably has her own views on the length of papers.
Yeah, and in your perspective, Judge, would you rather I submit something shorter for you or longer?
Short, I do. I think if the point needs to be made, there's no need to go on and on. 20 pages is very long. So, I mean, I guess if there's a rare case where the facts are so extensive that by the time you get through them, you're on page 19, perhaps then you would need more space. But I don't see a lot of reason to go beyond 10 pages, but 20 seems a lot. That's significant.
So what kinds of things would you be looking for if I came in and said, look, there's a really complex summary judgment motion? What are the factors you're going to look for and whether you would grant a request for an overlength brief?
Well, I want to know why you can't put it together in the 20 pages allotted. What is it about this case that requires you to go that much further? And then how many more pages? I mean, are you writing a novel? I mean, what, 50? Like, I don't know. I mean, I've never seen that. So I guess it would really be case specific. Now I'm a reasonable judge. So if it makes sense that they need more words, then have at it. But I think usually if it's a good, you've got a good argument, you don't need to keep at it. You put the case law in, you say why you should win and what the facts are, and that's it. But there's always an outlier, a case where it is needed. But I would really need them to explain specifically why they have to go beyond the limit and why it's necessary.
And Ryan, we already have these rules in our appellate courts. What is the impact of having rules like this in the trial courts now?
I think it's beneficial. I think there's brevity is appreciated by the courts. It's also appreciated. I have a small firm, so we have a significant amount of cases. And if my opponents are putting in 30 and 40 page briefs, obviously I need to respond in kind. I think this helps streamline the practice. If I was going to make an application, just to add on to what Judge Ryba was just saying, I have one case now where there's a 125 page complaint and there's 9 causes of action. So that would be a case where if there was a summary judgment motion, obviously we have to address all those causes of action and it could take a little more time. But as far as, I think this is a good thing. I keep going back to the client. I have some smaller business clients. This helps keep costs down. And that's really important to keep the judicial system fair. We can't have a VIP entrance where only the people with the right amount of money get to win. So I think that's important. And I think it's good that OCA is trying to keep an eye on that.
Okay, so on the flip side of that, people say, well, this is actually going to cost me more money because I'm going to have to edit it 4 more times to make it shorter. I'm actually going to have to get my brief done earlier so I'll know how long it is. There's another kind of piece of trivia in here, Professor Connors, which is bookmarking. I'm now going to have this thing to navigate around the brief. There's something that wasn't taken over, which is hyperlinking. And a lot of people hyperlink anyway. but I know that that is a little bit more controversial in the commercial division, where you have to have a site that you could click on and get right to Siegel and Connors on New York Practice, or younger on the commercial division. I'm kidding. How do you see these rules playing out in terms of, their requirements on lawyers? Do you think it's going to make it easier for lawyers, harder for lawyers?
When I'm hearing harder, especially for smaller firms, I just want to do some linking here. We're talking about the length of the papers. That's on page 48, Exhibit R of the materials.
Yeah, section 202.8-B.
Yeah, correct. I'll just note, I've seen this, but when I read this, where is, I don't think we can stipulate around these word lengths. I think
it takes the judge's approval. That's why it's a in the commercial division. Now, very often what I'll do is I'll call Ryan up and say, okay, I'm going to need more words for my opening brief. We'll agree the same thing on your opposition. And then we have to submit a letter into the court to ask for permission.
Good.
Yeah.
And then another incentive, I guess, now going to, this is Exhibit E in the material, page 21, the new rule 202.5. If you look at A2, it says if the memo, the affidavit, or the affirmation exceeds 4,500 words, it's got to include bookmarking. Now, let me try and describe that, because I think a lot of lawyers, I'm not sure I understand it, but bookmarking is really listed here. It's just an easy way to navigate around, let's say, the memo of law, where you can, on the front portion of it, tab on it and go to point 2 of the brief, or the affirmation might have exhibits. You can link to that or actually click on it. That to me is what I understand to be a bookmark. Then you've got hyperlinking, which in the rules does not seem to be required.
No, it's not. No.
Yeah, but it is required in the commercial division rules. If you go to page 72 of the materials, it talks about hyperlinking now in the commercial division. And I know in the second department, if you submit a brief, it has to have hyperlinks. And that's a little different. That's just that you cite a case, it allows the court to click on it and get immediately sent to the case itself. So it's somewhat different than bookmarking. But these two requirements, hyperlinking and bookmarking, scare a lot of smaller practitioners. And, at a larger firm, Steve, you might just send this off to people in the firm to take care of. But a smaller firm, maybe like Ryan's size, the lawyer has to do it herself, and it can be time consuming. So that's what I'm hearing.
Yeah, and then there's another twist, because you can also have hyperlinking to the NYSIF e-filing record. And that's the one, in my experience, it takes more time, because, I've started out with the Quinn affidavit, paragraph 8, and then somebody has to convert it to NYSIF number, whatever. On the other hand, I think for you, Judge, it's very convenient, particularly if you're spending more time not coming into a courthouse. You can just click on something, get the sites. And so from my perspective, if I could do it, I want to make the judge's life.
I don't think we don't really need the hyperlinks, because we have Westlaw. I mean, the hyperlink is helpful, but I think if in the bookmarking, I didn't even know what that was until Professor Connors explained it. So the rule is there, and I guess the commercial division's used to it, but I've never felt like it was too difficult to look up a case, or not at all. So to me,
but say I give you a link right to the affidavit, does that make your life easier?
That is definitely easier, and yes, it's definitely easier to go through. But then looking at the balancing of small firms having to know that technology, is it that much more important for it to be easier for me to review a case when the solo has to spend that much more time putting it together? So I guess you have to balance the equities. And I'm not sure if it's balanced. Sorry.
Yeah. Let's talk about the one that's the most controversial, which is Rule 19A, fact statements, where one side needs to put forth on its summary judgment what they think the undisputed facts are. The other side has to respond to it. Ryan, in federal court, how does this play out? And how do you see this playing out in the state court system?
In my experience, this goes once again to the reasonableness and cooperativeness of the attorneys. Some attorneys go too far with their statement of undisputed facts, and they take some liberties. I think it's really important to keep whatever statements you use in this very short, very unambiguous, almost like a pleading and a complaint. I think it adds yet another wrinkle to the motion practice, but I would imagine this helps the court decide, okay, we can tick off these issues. There's no dispute. I don't need to get involved in this. It should be able to streamline the decision process, which I have little to no experience writing. So I would yield to Judge Ryba on that. But as far as motion practice, now we have word count certifications, we have meet and confer, and we have a statement of uncontested facts or undisputed facts. So I think it's important practitioners really pay attention to this because, as we might be ramping into these new rules, sooner or later, judges aren't going to just let it pass. So I think it's pretty important that we get up to speed on it, but it doesn't really help the attorneys much. I think it's really a tool to help the courts in the decision process.
Yeah, and don't forget that when you state that fact, you also have to state support for it, the cite to the deposition, et cetera. So Judge, I know a number of our judges in the commercial division in Manhattan don't even require the 19-8 statements. They've opted out of them. Do you think this could help you deciding a summary judgment motion, or is it just more work for us lawyers?
I think it's just more work for you. I don't think it's going to really help because there's obviously the reason why the motion's filed and there's an opposition to it, there's a differing on opinion. So it's not going to resolve the case putting that information together. So I think it's just more work for you, to be honest.
So Professor, go ahead.
Some of the judges in the commercial division, instead of having parties file opposing 19A statements, they ask for joint 19A statements to show what issues are not in dispute, so that it's not sort of two ships passing and where the judge is unable to identify what facts are at issue.
Complete sense, Danielle. That would be helpful. A joint statement, definitely.
So Professor, a question came in over the chat. Suppose I fail to submit the required 19A statement. Could my motion be denied, dismissed? Do you have any case law on that? Particularly a case out of Saratoga, maybe.
Yeah, Steve, if I recall, you may have practiced up this way. Clinton County, New York, on May 6th of this year, Judge Lawless issued a decision. It's Royce, R-E-U-S. And Danielle, do we have that in the materials or a cite to it in the materials?
We didn't include it in the materials, but I can circulate the site in the chat now while you're talking about it.
Okay. I'll just, if you're keeping score, I'll give it to you. It's 2021 Westlaw 183-7673. And I have included that in the July 2020 supplement in section 281. And Judge Lawless.
Can you repeat the site once more?
I'm sorry.
Just repeat the site once more.
Yeah, 2021 Westlaw 183-7673. And it's Royce, R-E-U-S. And Judge Lawless there basically, in a motion made, I think only 10 days after the rules took effect, he decided it and he said the statements required under 202.8G of opposing the motion with the corresponding, statement of facts was not included, and said, I'm granting summary judgment to the defendant because of plaintiff's failure to comply with the rule. Now, he did go on to say that he would have granted summary judgment under the old regime anyway. When I wrote the case up, and you'll see this in section 281 of the supplement, I was looking for commercial division cases, and it has happened with some frequency. Danielle was helpful in providing me some of these cases, that in the commercial division, when this happens and it goes up to the appellate division, and maybe Steve, you're arguing to the first department, I should have been awarded summary judgment because Ryan Donovan didn't put in a corresponding statement of facts, and the court ignored the rule. And the first department has said, Judge Ryba is not bound by the rule. And, it's there, but she doesn't necessarily have to follow it. So, that takes me back to what are we doing here? But anyway, I'll leave it at that.
All right, there's another rule, Rule 19, 202.8D, that only allows orders to show cause if urgent and no replies. I think that was already the case. And then a second one, 202.8E, that I have to give the papers to the other side on a TRO sufficiently in advance. How do you handle orders to show cause, Judge? And does this change anything?
It really changes anything. I was just part one here and dealt with a lot of orders to show cause. Obviously, if there's a request for temporary relief, then the other side needs to be heard and needs to, I'm not going to sign that order before I have argument. So, I think it makes sense to file that, get those papers as soon as possible. But the reason why someone's filing an order to show cause is there's some sort of emergency that's come up and they need to have that looked at by a judge. So depending on the case, I mean, if it's about a tree being chopped down, they didn't know until it was, coming down. So the rules are great to set parameters, but there's always going to be reasons why they can't be complied with. And an order to show cause is an emergency request. So typically they're going to come in when they come in.
Yeah, this is the one change I think we see in New York City is that, usually I'm working on that brief on the order to show cause till like right up to the last minute. And so I would typically say to the other side, tomorrow I'm going to be applying for, emergency relief. And then they'll say, when can I get your papers? And it's usually like midnight. But then the court needs time anyway, and the court's not going to schedule the order to show cause for 10 o'clock. In the old days, we just hand the papers to someone as you came into court. It's not the way it's going to work in this world. All right, so let's turn to trials. Danielle, I know you have had experience with this. We had a major trial in the commercial division where we did direct testimony by affidavits. How does that help speed the case along?
So it's described by one of the team members. It's a double-edged sword. What it does is it allows the length of the trial to be shorter, particularly where it's, could be a 4 to 2 week trial, because most of and first of all, let me back up. This only happens for bench trials where the judge will be hearing all the testimony. And so in that instance, you can trust that the judge will understand and evaluate neutrally the evidence before them. And so there's an incentive to put forth your direct testimony in an affidavit. And it provides you a lot more time to organize what you're going to say. But at the same time, it also provides the other side the opportunity to review in detail what your direct testimony is. Also, so that's one negative. Another feature of this is that evidence goes in early. So you may be submitting your direct testimony before you've submitted your deposition designations, or you're still working on motions in limine. So it's sort of the sequence of preparing for trial is sometimes a little bit thrown off. But on the whole, it's viewed as helpful and happens often. One thing to consider if you are considering doing a direct testimony by affidavit is whether you want to negotiate for 1 or 2 live witnesses. Just because it does help or could help frame your case, frame your trial, you might consider making your company witness or your key witness have direct testimony live and then submitting the rest of the testimony via affidavit. So those are sort of the thoughts on how that does and doesn't work.
Good. And let me just get back to the last question we have, and then we'll try to conclude. So this is for you, Judge. Do you take into account in your consideration of like the equity, how big the case is? Is this just a $10,000 case versus a $10 billion case? Is this a case of massive public policy importance versus, I know everybody's case is important, but in terms of, I know, for example, there's no proportionality requirement in the CPLR, but there is in the federal rules that we brought into the commercial division. How do you take that into account? How sizable the case is, how complex it is. What does that say in terms of the equities?
With regard to this specific rule, direct
With
testimony,
any of these rules, I think this question is really about the commercial rules in general.
I think, well, I think every case should have this same level of consideration because $10,000 to one person is similar to a corporate dispute over millions. So I really will take each and every case and look at the reason why they want a waiver of the rules, and I will determine it on a case by case. I'm never going to just look at a category of cases and assume that that case should have more deference given to it with regard to the rules being waived. So I can't just say overall, this is the type of case. If it's a complex complex medical malpractice case, presumptively it's going to need to have the rules waived, because I think that each case is different, and that's how I've been viewing each case that comes before me since I was sworn in.
Good. So we're going to get to the final round in 1 second. But I think what you've
Steve?
heard is there's no, you go ahead, Professor. Let me just finish.
quickly,
There's no one
that-
size fits all, but Professor, go ahead.
That quickly, the proportionality idea that you mentioned, based on the size of the case, that is, they sneak it in under request for documents. So you'll see that in the new rule 202.20-C, subdivision E is in Edward on page 33, that's exhibit K. You'll see reference to disclosure obligations under the CPLR and proportional to the needs of the case, which I'm sure lawyers are going to grasp at for good reason.
All right, so let's go to our final code, which is rules, RULES. I don't know if you want to put that up, Jeff, or not. All right, and so it's RULES is the last code. So we're going to give everybody one last comment and a speed round here. And I think what we'll do is we'll ask, what do you like about the rules? And is there anything that you wouldn't translate from the commercial division over to general practice? And let's start with you, Ryan.
Well, thank you for allowing me to be here today. I think the rules overall, I'm happy with them. I think it codifies a lot of common sense. I know there's some conflict that professors brought up, and obviously that can't be ignored. But in my practice, I think this will hold people accountable, allow us to push cases, and I think it creates a level playing field with clients of different financial means. As far as what I don't think should be brought over, I believe that the issue with the discovery, as far as the depositions, I don't have a major problem with the time limit, but I think there should be something in the rules dealing with multi-party cases. So there's some more guidance for the courts. I feel when we have what I'm seeing in my federal practice, when you have multiple defendants, it get confusing and there's not a lot of guidance there. So it really leaves the practitioners not sure what to expect. And you might be asking for permission prior to the deposition when in fact you might not know until you're in the deposition. And if you don't get that extension, then you might be prejudiced.
How about you, Danielle?
I mean, my take is that a lot of the stuff was already elsewhere or required elsewhere, or sort of part of common practice. Things that should or should not be moved over, I don't have strong feelings really. I feel like some of the commercial division rules are created for, higher stakes cases, meaning like higher spending cases. And so some of the resources required to do the linking and the bookmarking, where I might have access to a paralegal or someone to help, seem, according to Judge Ryba, a little less useful outside of the commercial division.
Professor Connors, what do you like about the commercial rules and what wouldn't you bring across?
What I don't like is the fact that the state bar has asked for a stay. It's been announced that there was a stay and the courts have been silent. So I, as an author, and I'm sure so many of you out there as practitioners are wondering, do I need to comply with these? And it's odd, but I think the court should come out and say, we're going to consider issuing a stay, we're going to decide by this day, or we're not going to stay these rules. That would be number one. I think I don't like a lot of the disclosure aspects of the rules. I don't know that they add much to what we have in a meaningful manner, but there's a lot of, particulars that if you miss, you're in trouble. And I do think, and all of you have said it, that there's a lot of common sense here. And if you follow these rules, you'd probably do better in practice. But to have, what is it, 6 sets of rules out there for lawyers to follow now? It's time to get together and put revise the CPLR and try to put as much as possible in one document to make it easier for the lawyers to practice and more economical for their clients. Thank you.
Thank you, Professor. And we'll give you the last word, Judge Ryba.
What I don't like about the rules is the way they were rolled out in December during the pandemic with literally 0 input from the bench and the bar. I do think my theme is always less is more. So having more rules, like Judge or Professor Connors indicated, is just more difficult to follow, because I know that attorneys want to follow the rules, but there's so many of them. At times they don't even know what they are. So what I worry about is that this will cause adversaries to kind of take advantage of each other in a sense that maybe an attorney who knows the rules will try to move to dismiss somebody's case, and depending on what judge they have, they might get it dismissed. And so it's really going to be, instead of uniformity, I think it creates a lot of dysfunction depending on what judge you have, what jurisdiction you're in. Is your judge more liberal? Is your judge going to be somebody who says there's no waiver? So to me, it causes a little bit more chaos and unknown in a time that we really don't need it. So that's my final say.
Well, thank you, everybody. Danielle, do you want to give us some closing remarks?
Thank you, everyone, for coming to our panel. It was great to get together with all of our alumni, and I know there's a lot of familiar names on the list who attended today. So thank you for all coming. I think it was a helpful discussion.
Thank you. And don't forget to write to the State Bar if you have thoughts. Thank you, everybody.
Bye.